So we'll just start in 1 minute and we'll get going. About 20 seconds, so we might come in as we go. I hope it's really got PC on. Not sure we can do about that. Do that, and then you can. That's just news for you. H2. Right. Okay. I think we're going to. Seems like everyone's here, so we're going to get started with our GDPR webinar. So I'll introduce you to Stephen Mitchell.
Hey, good morning. Steve Mitchell. I'm the Chief Operating Officer of Spencer Academies Trust, and have been working through GDPR now for a long time since it's come out. And yeah, we are 1 month away today from the start of the regulations. So I'm sure everybody's aware of that, and I'm sure people on this webinar have differing levels of experience with GDPR and implementing it in your own organisations. Today, we just want to try and answer some of those questions, run through the basics of where GDPR is at, and provide some information and best help tools as to how you can prepare your organisation for what's coming on the 25th of May. So we've got a presentation we're going to run through. Feel free to interact with us either by interrupting our conversation, asking us directly, or using the chat functions on the screen, and we'll try to answer the questions. So, the GDPR, Data Protection Regulation, comes into force a month from today. It is an iteration and build out of the Data Protection Act, and will apply right across the entirety of Europe, even despite Brexit. First, I just want to use perhaps what I found to be a very good video that was developed 10 years ago by Steve Jobs when he was talking at a conference, and he explained very succinctly and the best explanation I've heard so far of what data privacy actually means within an organisation. Just want to do that for you, clip.
One theme that we want to ask everybody here, and one speaker at great length, is privacy. Sorry, Mark's here. But, hey, Mark. So there seems to be to have been a mistake, starts buzz. There was my collection of inadvertent. Talk to me about that. How privacy looked at differently in Silicon Valley than in the rest of America? No, we've always had a very different colleagues. Privacy doesn't exist. We worry a lot about location. And we worry that some 4-year-old is stalked and something terrible is going to happen to our phone. And so, before any app can get location data, you don't make it a rule that they have to put up a panel and ask, because they might not follow that rule. They call our location services and we put up the panel saying, this app wants to use your location data. Is that okay with you? Every time they want to use it. And we do a lot of things like that to ensure that people understand what these apps are doing. That's one of the reasons we have the curated app store. We have rejected a lot of apps that want to take a lot of your personal data and stuck it up into the cloud. A lot. So we're really old. A lot of people in the Valley think we're really old-fashioned about this. And maybe we are. But we worry about stuff like this.
But aren't you also going to be moving more into cloud-based things?
Are we going to be moving more into cloud-based things? Sure.
But doesn't that inevitably...
No. Privacy means people know what they're signing up for in plain English and repeatedly. That's what it means. I'm an optimist. People are smart. And some people want to share more data than other people do. Ask them. Ask them every time. Make them tell you stop asking them. They get tired of your asking. Let them know precisely what you're going to do with their data. Okay. That's what we think. Thank you.
And for me, that sums up exactly what GDPR is about, and it was very interesting that Steve talked about that 10 years ago, way before the GDPR was even a thing. So hopefully we can all agree that data privacy sums up really nicely in those concepts of making sure that people know what they're signing up for, and they're giving explicit permission for it, and they know exactly how we're using their data, and we're telling them. Now we're just going to run through the concepts of GDPR, and just to emphasize that GDPR is working across Europe. It's a pan-continental-wide development of the law, and it applies now not only just data controllers, those organizations that do it, but also data processors. So for the first time, we're picking up the obligations on our supply chain and those firms that you may use for processing of data. And as I mentioned at the start of the webinar, despite Brexit, it's still coming into force 1 month from today. So in terms of personal data, the main categories that we've got within the data, there's much more detail than previously under the Data Protection Act. Whereas before in the current legislation we have to look after, it's all personal person. Now it picks up definitions of data in which you can identify people through that. So things such as IP addresses when we use computers. Within a school environment, this is likely to be less of an issue than in a business or a social media-based environment. But there are still likelihoods that your web developers are potentially tracking IP addresses of people that are visiting your website. And that data is actually becoming under the guise and the remit now of GDPR. It also applies not just to computers. There's been a very much a school of thought, and I've been talking to school leaders around the country, that GDPR only applies to electronic data. It actually applies also to the paper you hold in that filing cabinet to the left of you, or the box of paperwork that's on your desk. All of that falls into the transparency requirements of GDPR. So there are some rules of how we must be looking to process personal data moving forward. First of all, I think we'd all understand and expect that fairly and transparently. So we've got to be much more open. To me, it's about building a culture of making sure that we're putting privacy design into the way we work. There are a number of reasons by which we're allowed to collect data and specific and legitimate purposes. We've got to know what we're doing, and I know everybody is tied up with a lot of work in trying to work through these principles at the moment. Make sure that we do know what data we're collecting. Clearly, it's going to be accurate and relevant, and that allows us then to be able to identify it and pass it on to data subjects, and only to keep the data for as long as we need it to be. Data security is a massive thing now for the schools, and we're all very conscious that we process a huge amount of personal data, some of it around vulnerable schools. And that way we need to ensure that we are looking after the processes in which we operate, also that we're taking our data security seriously. I mean, we've just got to look at the news of Facebook and what's happened with Cambridge Analytica over the last couple of weeks. The obligations on us to make sure that we process our data securely and we know something is significant. In terms of consent, consent is one of those things that's one of the bases of being able to work through and being given permission to be able to process the data, but it must be freely given specific and unambiguous of individuals' wishes. Now, previously, many organisations have relied upon opt-out clauses. We've now got to use those in the future, and any control you gain is what to be positively consent given. And similarly, people have got to have the right to be able to withdraw their consent. So going back to what Steve Jobs was saying in terms of only processing data for as long as we want to have it, and asking people continuously, if someone wants to withdraw their consent for the processing of data, and we've got to provide them a means by which they can do that.
So here we're going to talk about the individual's rights. So these are about the rights of the individuals under the GDPR. So the GDPR has created new rights for individuals, which obviously some do exist in the GDPR, but these are just strengthening what they already have. So one is the right to be informed. So every single person has a right to know what company or school, what data they have on them and how that data is going to be processed. They have the right to access, so they can be able to access that freely. They put in a access request. They are within right to receive that back.
It is the ability for organisations to offer the data subject the chance to pose the data. So if the data is wrong, the data subject can come to you and ask for the information to be corrected, and you have to correct that information. And similarly, if a data subject wants to have you remove their information they're holding, they have the right to do so. Now, within a school environment, and we'll come on to this, within a school environment, a lot of our legitimate reasons for processing data mean that the data subject can't automatically ask you to take their data away. So if you need to use that data for a particular legitimate purpose, you can do so. So these rights do not conflict with your rights to process data legitimately. Restricting down processing, data subjects can have the right to ensure that you only use the data for which you told them to do so. And that's why an awful lot of the work that you're doing now in terms of identifying what data do you hold and why do you hold it is absolutely crucial. The privacy notice and the data subject notifications you issue will allow you to dictate what you can process it for, and if we don't identify those clearly, individuals will be able to ask you to stop processing their data. And finally, individuals now in the GDPR have the right to ask you for a copy of their data, and we have an obligation to be able to provide the information to them that we hold in a format which can be given and used elsewhere. Data subjects obviously have the right to object to information we hold as well. Moving on into the right to be informed, this is really at the heart of going back to what privacy means, which is that we've got to provide the fair processing information and a privacy notice. Now, privacy notices are one of those things that invariably you may well have a copy on your website, and chances are that before GDPR came around, it hadn't necessarily been reviewed in a long time. But the privacy notice is quite a fundamental aspect of GDPR and sets out the context in which we are actually individual personal data and how we're processing and what we'll do with it and how we'll respect the privacy of the individuals. Under GDPR, individuals can access their data to verify the lawfulness. We will declare in our privacy notice why we're processing the data, and this gives the individuals the right to access that and move forward and to obtain further information and how we're processing their data and get confirmation of that. It is very similar already, and I'll talk about how the GDPR is a build-out from under the data protection that we currently work at, and we already are familiar with subject access rights and data protection. Previously, under the Data Protection Act, we were able to charge costs for accessing information. Under the GDPR, we're not allowed to do that, and the information must be provided free of charge. And the rationale for this is that the individual's own data that we're processing, and therefore they should be able to access it. And the time limits come down now as well, so we've got to be able to provide the information within a month. Clearly, and anyone will understand that if you're aware of an organisation that holds personal data about you and that data is incorrect, you'll want to get it changed and updated, and therefore the individuals can now do that. And we must be able to respond to those requests within 1 month. And similarly, if the individual then wants to remove their data, clearly Google have been at the forefront of this right to be forgotten over the last couple of years. This is now becoming enshrined in GDPR. And we can request the removal of personal data when it's no longer required, and that requires us to do some real in-depth thinking now about how long do we need to hold personal data for. And if we just consider briefly, for example, the concept, I know this is one of the conversations we've been having in my own trust of schools at the moment, is do we allow people to remove the personal data of students' performance data after they've left the school? There's a legitimate question there about whether we actually need to use that data the process of being able to drive forward student progress and look at trend analysis and look at how can we improve our intervention. The right to be forgotten is not an absolute right. We need to be able to prove that we don't need that data anymore. So we can actually refuse request for data. If we've got a legal obligation to hold it, and certainly within schools, we do have a number of legal obligations to hold students for a period of time. Freedom of expression of information is absolutely, that's largely going to be used by the media organisations, and the public health interest and the public interest is something that is not likely to affect schools. Legal claims, there'll be many times, and I think we'll find as GDPR beds in, and once we get past the initial wave of subject access requests, I'm sure we're going to be getting after the 25th of May, that we'll end up with some situations where there are legal claims coming in, and then you can refuse to not delete data on the basis that you'll need it to look after legal claims that are in the necessary interest of the organisation. So in terms of restricting processing, the Data Protection Act is very similar to GDPR in that sense. We can only store the data that we need, and we can't process any further. We have to identify how we want to process data, and then only use the data for that sense. And if we want to restrict it down, where an individual has actually challenged the accuracy of the data, we're actually not allowed to process that data anymore until we rectify the research is correct, or we have actually rectified the information that may have been incorrect that we had on our systems. If we're not processing our data and this receives a challenge under the basis of legitimate interest, and you'll see guidance on the TheSchoolBus website about legitimate interest, and it is primarily the basis upon which you will be relying to process data. You can consider whether the organisation has the grounds to override that. So if we have, as schools do, a legitimate interest in using data to provide education to children, we can rely upon that legitimate interest as the basis for continued processing, even if the individual has suggested they would not like the data to be processed. And if we don't need the data, but we need to carry it out to maintain our defences moving forward, then we can do so. But if we are going to override an individual's right to restrict the processing of data, we of course need to tell them. This is a key change to data portability now in terms of data rights that people have got moving forward. Individuals are now able to download and copy their own personal data. I'm sure many people that have seen news on Facebook recently coming out, particularly after the Cambridge Analytica stories, where you can now download your own personal information. And this is not only a response directly to that Cambridge Analytica situation, but it's also a response to the incoming GDPR. And various other social media companies are doing that as well. I've seen this morning that WhatsApp, the social media messaging platform, have just introduced a functionality where you can download the data that WhatsApp hold on you as well. And this information is all part of the move from the time of GDPR. So we've got to be able to provide to data subjects the personal data that we hold and the information they've provided to us, and where we have the processing, what processing they're doing with that information. And we've also got to be able to identify whether or not that is subject by automated means. To be able to comply with this particular part of GDPR, we have to be able to provide the personal data. That may well be just a download from the various different databases. But it's got to be in a manner in which it can be useful for these data subjects. So if, for example, we're downloading a backup file of an individual's student records, that is unlikely to be acceptable under GDPR as a which we can transfer it. So we need to look at how can we put that data into Word or Excel or similar.
Does anyone have any questions? Just we'll have a quick pause. If anyone's got any questions on what we've just spoken about, if you'd like to type it in the chat, then we can answer anything up to this point. Don't want to sort of if there's a few things that you're querying, just please pop it in the chat and we'll respond to that and help you out. So the next section we're doing is the right to object. So individuals may object to processing based on legitimate interest. In this instance, you can stop the processing so you can provide legitimate grounds. However, I think under schools, there obviously it's a clear legitimate interest to be processing of people's data, and obviously data of staff and third parties. They also might object to having their data processed for direct marketing. So this is why when you send out, if you include everything in your privacy statement, in your terms and conditions, that individual knows exactly how the data is going to be processed, and that can literally be everything from sending out newsletters, sending out bits of marketing about the school. They have a right to object to that and opt out. Obviously, when it comes to schools, there will be certain things that, you know, pupils and staff can't opt out of, and that obviously falls under legitimate interest. This is the right decision making and profiling.
Yeah, automated decision making is something that is used by a lot of mainstream commercial businesses. So they're making decisions on essentially creditworthiness or ability to be able to service you as a customer. It is not likely to be something that is massively influenced within the school environment, but we need to consider whether or not we do use it. It may well be that we are carrying out functions through a website where we're collecting information and making decisions on the basis of how people are filling in those forms. If we are using automated decision making and profiling, then we really do need to consider how the individual's data is protected against the risk that we're making decisions.
I'm going to go and set my mates. You talk to my melody and then disappear to my mate. We're all going there for showers and I went, bye.
Thank you. Asking a question there.
In terms of people's personal data, there are now new provisions designed to protect that, and we've got to make sure that we are communicating everything about data privacy and the data we hold and how we're processing it in an age-appropriate way. This means all of our documentation there needs to be written such that the people whose data we are holding can understand it. This becomes quite a complex situation, particularly with primary and infant schools, where we've got such that the children themselves can understand what we're doing. And you'll find on the TheSchoolBus website now there are new privacy statements and processing statements written in such a manner that are free to download as a member and you can utilise across your schools. Whilst we do have to provide information in an age-sensitive format, GDPR does actually go on to say that you can't give consent unless you're 16 years old. And whilst in schools we're very familiar with having to obtain parental consent for that, it's nice to have this enshrined in law so we know exactly where we do or don't need to be able to get consent. If the request for erasure of data has come in, then we have to make sure that we're processing data to where consent has previously been given, and making sure we're taking out all of the data that's associated. If a request for erasure of student data comes in and it's carte blanche as that, and they're asking us to delete their entire student records, we need to consider, A, where do we need to keep the data for our own legitimate purposes of managing the school performance moving forward? Where do we need to keep the data for the legal basis of being able to report student records to the relevant authorities moving forward? But thirdly, what other data have we had and where they have given us express consent before that they now take that consent away from?
Now we're going to move on to accountability and governance. So obviously under the GDPR, you expect to put comprehensive but proportionate governance measures in place, and they can minimise the risk of data breaches and protect personal data. So the new principles will require you to demonstrate that you comply with the principles and states that compliance is an individual's responsibility. So these are a few ways in which you can demonstrate compliance. So obviously having internal data protection policies, obviously one that's in line with the GDPR, having staff training, regular reviews, ensuring that all staff not only have read the data protection policy, but they also understand it. They also know what's included within the privacy statement and the terms and conditions, and they know how data, not just pupil data, but data across the whole school is actually being used and processed. Obviously maintaining relevant documentation on activities, so it's good to keep some logs. One is any data breaches are all kept in a log, how you process data is kept in a log, subject access requests, all this information needs to be logged and kept. So it can all be reviewed in case there is a data breach. So obviously, schools have to appoint a DPO. And I know there's been a bit of confusion over this. We're getting quite a lot of people say, can governors be a DPO? Who can be a DPO? And obviously,
sorry.
Oh, hello. Sorry, someone asked me a question. No, not sure. Yeah, we've had quite a lot of questions on who can actually be a DPO. And realistically, apart from the head teacher, anyone can actually take on the role as a DPO. Obviously, it is advised if you have a large school and you are part of a MAP, then to maybe appoint an external DPO. But actually, this is a role that can be undertaken by a member of staff or a governor.
Yeah, we're going to talk more about data protection impact assessment. These are a really key aspect in the arsenal that you have to be able to make sure we're dealing with data, personal data, effectively and securely, and for the reasons we want to, and we're understanding the impact that DPIA and data protection has on individuals. There's a lot of work being done on data protection impact assessments, and it is a key part of the policy, and you'll find on the website templates that can be used to support DPIA. Whilst they're not an official part of the Data Protection Act, it is a way to help us ensure that we are compliant with both DPIA and GDPR. Jane has just asked a question about conflict of interest in DPOs. Jane, if it's okay, that's on our next couple of slides. I will answer that point specifically when we get there, if that's okay. So going back to DPIA, it can address more than one project, and it's not a assessment that takes a very long period of time to carry out, but it does give a good framework for doing so. What it does is allows you to work through the operations that you're carrying out and where potentially there is a risk, and look at the necessity and proportionality of the processing in relation to the purpose for which we want it to do. But further than that, to put boundaries on actually where we're processing our data, as the way they operate. It's very easy for the way we operate to be unbounded, and so it's just to keep on moving into the areas. And look at the necessity and proportionality of it allows us to put at the heart of that decision making the data subject and whether or not we're breaching something or not. Building on from that is the risks to the individuals, and any data processing we have may have unwanted risks and unwanted harm to individuals. Being able to document that we've considered that gives you some defense if there be a breach further down the line. So then gives you obviously work through to the next stage to be able to put in place measures to mitigate that risk. Obviously, there are a couple of number of thresholds there, and these will apply particularly to multi-academy trusts. So if your organisation has less than 240 employees, you must maintain records of activities over higher processing, and they're on the screen. And none of those are particularly special or unexpected that you'd see. But if your organisation has more than 250, you've got to hold additional internal records over and above what you would do as a normal organisation. And this includes, you've got to declare in ethical practice declaration, even in the basis of your privacy policy, who your data protection officer is and who your organisation is, the purposes for processing, the categories of data that you hold, particularly if we're transferring data to make lines of the country, referencing retention schedules, and there's a very good schools document retention schedule that's been produced to make sure there's a little bit out with this. And a brief narrative about the schools in place, and that will involve confirming whether or not tools are used or whether we're looking at protection. Jane, I hope I'll answer your question here within the DPO. So within the GDPR, you have to appoint a DPO if you're a public authority, carry out large-scale systematic monitoring of individuals or processing of special category organisations. There has been a lot of debate over the last 12 months or so as to whether schools will actually be required to appoint a DPO. And yeah, I don't think there's been any specific guidance that rules that in or out, but the general trend has been very much along the route that schools should be appointing a data protection officer, and certainly it would be viewed as good practice to have that position in post, not only to oversee how we are collecting any breaches, but being able to respond to it and being able to be transparent about our data upfront, managing data. Whilst the role of a DPO is not a full job description, their tasks are to make sure that employees are aware of the obligations and to look at the compliance of the GDPR and to be the first contact authority where there is either a breach or with individuals whose data is being used. What the GDPR does do is say that an individual who carries out the function of GDPR, of a DPO under GDPR, they must report the highest levels of management, and it expressly forbids, for example, in schools, the case of a head teacher being the data protection officer, but they've got to have an ability to report directly to the head teacher or even to the board of governors. And if you appoint internally to a member of staff within the organisation, it can be anybody within the organisation, and as long as they do not have a conflict of interest in terms of defining how the data is being processed. But they've got to have a direct route to the top line of management and the DPO act. Similarly, GDPR makes a very clear point to this. You can't discipline anybody for performing their DPO duties. So anybody that's wearing the mantle of data protection is confident that they can carry out their reporting and be able to highlight any weaknesses in the system without fear that they'll be disciplined as a result of doing so. And the schools have to give their data protection officers sufficient resources to do that and to be able to meet their obligations. And there is no obligation that any person carrying out a DPO is an expert within the realm of data protection, the field that's qualified. There are many, many training courses out there being developed and offered for data protection officers. There is no formal accreditation that is recognised by regulation for data protection officers. You have to be confident in your own ability that you know the ins and outs of what you need to be managing the processing the data of.
What everyone microphone, quite a few people get received in the external, so we can just check that the microphone is muted.
Somebody's got to try. Please.
Everyone has their microphone muted, please.
Thank you.
Sorry about that.
So coming back to the data protection officer, it can be an existing employer, it can be an outsourced aspect of the organisation. I mentioned before there's going to be no conflict, and I've certainly seen a lot of debate about whether or not the role of an SBM, or school business manager, is the role of a DPO. There is no right or wrong answer to this. It does come down to that issue of interest. Some school business managers will be responsible for choosing how data is processed within their schools, and if they are that person, then they cannot be the data protection officer. However, if the school business manager is more involved in how we process data in the student files or other person aspects, then they can have that remit. It really is a conversation between the head and the public to identify the person. It could be an SDM, and somebody's raised the question of whether or not governors can fulfill the role of a DPO. Absolutely they can. The same issue of conflict of interest apply. If a governor is being appointed a DPO and has the relevant expertise and knowledge and accessibility to the school to be able to function, I would suggest that it should not also be the same person that's responsible on the governing body for example, safeguarding and reviewing how students are kept.
So the next thing we're going to talk about is data breaches. So yeah. Second, have that microphone muted. yeah, please about that. I think there's just a bit of external noise going on. So just check everyone's got their microphone muted. Thank you. So this GDPR will require all organisations to report certain types of data breach to the relevant supervisory authority and, if necessary, the individual affected.
Yeah, one of the requirements under data breaches now is the recognising when a data breach occurs and manage that process quickly. Data breach in terms of leaking the system out of the relevant sandbox you've put within your organisation. But we've got to notify the relevant authorities. In this case, in the case of the UK, when it happens, you've got to be able to identify what information has been leaked. The contact information what happens, and if it's carried out to the Okay, so in terms of being able to identify the data taken and any of the data lost, we've got to be able to identify it and identify it relatively quickly. One of the time frames that's been introduced in the GDPR is the ability to be able to notify of the breach within 72 hours of the organisation becoming aware of it. Previously, this wasn't a requirement in the Data Protection Act. The organisation had to report within a reasonable time frame. We now have to be able to report very, very quickly, and that's why there should be a significant amount of work undertaken to ensure we have systems in place and we develop a culture within the organisations that we're reporting data breaches. One of the conversation points I've had multiple times with schools is the process of whereby putting an awful lot of systems and processes to identify a breach, and is this then a breach of our discipline policy, and are we into various different performance management aspects should people carry out data breach. And one of the examples I use is that within schools we do an awful lot of trips, and you'll be able to envisage this situation from within your own organisations. 8:30 in the morning, a teacher gets on the bus with 30-odd children, and in their backpack is a list of all the parents' contact phone numbers. And that's just good planning, because we need to be able to contact parents should something go wrong. But they've had a great fun day out at the British Science Museum and learned all kinds of fascinating things. At 5 o'clock, the school bus gets home and everyone gets off the bus and the teacher gets off the bus, but the piece of paper with the parents' contact details on has been lost somewhere in London during the day. That itself can represent quite a significant data breach, because you've got the personal contact details of 30+ parents now outside the sandbox of the school organization. If the organisation has a culture whereby it would discipline under that kind of basis, it is highly likely that the individual may not choose to voluntarily disclose that a data breach has occurred, and therefore the organisation won't know about it. So it's absolutely crucial that you give consideration to how do you develop the culture such that you are aware and being made aware of data breaches when they have taken place. There has been a lot of scare stories about the fines that are eligible under GDPR, and they are there. It is up to 20 million or 4% of an organisation's global turnover. Now, clearly those numbers are significant and very large compared to most schools' operating budgets. It is highly unlikely that a school would be fined anywhere near these level of details, particularly if we have good systems in place to show that we are taking data security seriously. So this moves really on to where I was talking about creating a culture and making sure that we have the breach detection in place so that when something does happen, people know they have to report it to the organisation's designated data protection officer, and that that person is authorised to investigate quickly and to be able to make a disclosure as we need to do so. Certainly I found school environments to be very collaborative, very wanting to have people informed and take a consensus view on how to move forward. 72 hours isn't a huge amount of time, particularly if you've got a relatively serious data breach going on within your school. You need to be able to act quickly, and we need to have a culture that does ensure we're reporting these frameworks quickly as possible.
We've got a question in from Jane. Regarding training, are there any plans for the school bus to provide a training presentation that could be shared with staff of all levels? Well, actually, this presentation that we're doing today has been taken from the school bus, and obviously at the end it does have quizzes and things, and it includes staff handouts which can then be given to staff, which includes all the necessary information. And as a thank you to everyone attending our webinar, I will email this presentation out to all of you so it can be demonstrated to our staff. And I will go on to the school bus and just to give you a show. If you're not a user of ours, if you take out a free trial, you can actually access 5 of our resources for free. So this is our resource pack here, and it just includes sort of what we think is necessary within a school. So obviously we have our GDPR data protection policy, guidance, we have checklists for governors and MAT trustees to ensure that the school is up to date and where it should be to prepare for the 25th of May. Here are obviously what Steve mentioned before about our privacy notices, obviously school workforce, pupils and their families. You also have in here somewhere a child-friendly privacy notice. This obviously can be given out to pupils in secondary school, obviously the older ones, so they know exactly what they're consenting to. And these obviously are all our different tools that we have. So it's an information aspect register, disposal of records. So here is where you log, how you dispose of records, why, how well, and everything that you've done to ensure that that's been done in a compliant way. We also have our data breach log. So if there are any breaches within your school, this can be logged here on our trackers. And we have, this has just come in yesterday, just one we did yesterday this is from the DFE toolkit about photography in schools. We've had quite a lot of questions on that recently about, if we have photos of ex-pupils up on the walls, can we continue to use these? What can we put on the website? Obviously, we all have our QAs, which are done through our need for the help. So you can come and ask us any question, or you can actually request any document. So actually, our GDPR policy was done by a user, and they came onto site, clicked request a document, and said, I think this was July last year, could we have a GDPR policy? So our turnaround time is actually 3 days, and it's obviously included in the subscription. You unfortunately don't get that this nice thing with the trial, unfortunately. However, with the subscription, that is obviously all included. We can make logs, trackers, privacy notices, letter templates. So this is obviously quite a big one. I think it's one of our most downloaded at the minute. So this is something that all schools should be doing. So you should be sending out a letter, data processing agreement to all your third parties to make sure that they are also compliant. Obviously, that's something we've been doing as a company. And unfortunately, there have actually been some companies, some services that we've used that we've had to actually walk away from, even though we've been using them for a long time because they're based in America, and they've turned around and said, we don't have any plans on being GDPR compliant. So unfortunately, we've had to take a step away from that. But everyone else we've been sending our letters to, and we sort of advise all schools to, and obviously this is included with the trial, so you can download this letter template and send that to all your suppliers to make sure that they are compliant and you can carry on using their services.
Yeah, it's a key point. We touched on it in the presentation, is that the GDPR now applies to not only data controllers, which are yourselves, but your data processors. And as a means of facilitating that, to comply with GDPR, you should have a formal agreement with all your suppliers about them processing personal data and how they do it, and at the very least, matching your standards. That is a letter which is free to download, which you can send to your suppliers to ensure that they respond to you relevant confirmations that you need.
Yeah, so if anyone has any questions, we will be going live on Facebook at 11. I think obviously quite a lot of people will be attending that session. So if anyone has any questions that would like to ask myself or Stephen, just type it in the chat box. And if not, I will send you the presentation that we've just gone through. I will send that to all of you so that you can use that within your schools and your governing body to make sure you're all reading from the same hymn sheet, as it were, and also the link you were saying before about the
document retention.
The document retention. So they'll all be sent to anyone. So yeah, thank you all for attending our session today. Thank you, Steve, for your wonderful insight.
Thank you.
And yeah, so if anyone, we will be going live on Facebook and our Hub Leaders page at 11, and that will just be a live QA, sort of all the questions that come in, we will sort of try our best to answer for you. And like I say, in the meantime, oh, I had a question. What about retaining data about exam results as schools can be asked many years later?
Yeah, and thank you for the question. I think that was one of the comments I was trying to address within the presentation in terms of should you be able to keep student data as to how they performed years down the line? My personal view on that is that it's a part of an inherent important part of the school being able to direct their own future strategy and moving forward. As a safeguard to the personal data in there, arguably you could say that you need to pseudonymize or anonymize the data so you're not being able to identify the individual concern, but you can still see their progress over time and how they've moved through the school and developed and the impact of any interventions. I would say that being able to keep that data is a legitimate interest. Arguably, you should be able to anonymize the data at that point.
Yeah, I think that what I've read is that as long as you outline your retention periods within your terms, conditions and privacy statement, then at least the people in the school know exactly what data will be retained and for how long. So we have another question that is, we want to do some work in our school to understand our attachment patterns, i.e. can we use pupil postcode to this? We already have that data, can we use it?
Yes, you can. You can use any data as long as you have permission to do so. So you have to ask yourself, how was that data obtained originally and what information do those data subjects have over to process that data? If there are students within your schools and you're looking at the postcodes that you have, presumably there has been some contact with the parents of those children or the students themselves to say that we will use your data for the effective running of the school. And it would likely be that analysis of catchment areas fulfills within that category. Another question in terms of my experience of mapping data flows within the schools and the trust. This comes back right to the nub of preparing for GDPR, and it's probably one of the very first things you should be doing within your trust is trying to understand what data do you have. And certainly when I was looking at this in my employer at the time when we started looking at GDPR, the data map we ended up with was not one that any of us would have recognized when we started the process. There was an awful lot of data within schools, and even more so within trusts, that gets processed for a huge variety of reasons that you don't necessarily think about straight away. So my advice on data mapping is that it's an essential part and a hugely opportune area where a school can actually make improvements in the way they process and the way they work. But it does take a lot of work. It's a lot of effort to be able to get all of the data down. And it can't be done by one person, or it can't be done by the SLT either. It needs to be a cross-organisation approach. And my suggestion would be that you appoint a team to look at this data processing from all different levels within the organisation, say how are we using this data, and then you stress test that by talking to other individuals and saying, has this picked up everything that we know about how we use data?
Brilliant. I think that's it for all the questions. So yes, thank you all for attending, and apologise for the interference at the beginning. So obviously halfway through we realised we could actually mute everyone. So unfortunately hindsight's great. We should have done that at the beginning. But regardless, thank you all for joining and being a part of our webinar today. And good luck for the next 4 weeks. If you ever need anything, whether you're a user of the school bus or not, we are here and we want to help schools. So if you have any questions, you all have my email, and yes, please give me an email.
Okay, thank you. If you want to contact me, my Twitter handle is I'm Steve Mitchell, and I can be reached on there anytime.
Thank you all.